Bristol County District Attorney Thomas Quinn's office violated the Massachusetts Public Records Law by claiming a laundry list of exemptions to withhold information about police officers accused of crimes and other misconduct and assessing an excessive $500 fee for some of the records, according to a lawsuit filed by the Mass Dump in Suffolk County Superior Court on Wednesday. It's the second transparency lawsuit the Dump has brought against the DA this summer. In June, the Dump took the Northwestern District Attorney's Office to court for blacking out the names of accused officers from its so-called Brady disclosures. These documents are used by prosecutors to notify criminal defendants about allegations of dishonesty or other misconduct that can be used to challenge the credibility of officers testifying against them. In January of 2022, the Dump made requests to both DAs for their disclosures and other related records. The DAs claim that the names of officers accused of crimes are protected by the state's Criminal Offender Record Information, or CORI, statute. Despite a 2020 Massachusetts Supreme Judicial Court ruling that arrest reports of police officers and other public officials cannot be withheld under this law. The DAs also claim that the names of officers accused of any misconduct are protected by the personal privacy exemption to the Public Records Law, even though, in 2020, the state legislature updated this exemption to explicitly say that it, quote, shall not apply to records related to a law enforcement misconduct investigation. The Dump appealed to the Public Records Division of the Secretary of the Commonwealth's office, despite 3 findings, each by then Supervisor of Public Records Rebecca Murray, that the DAs had not provided a legitimate basis for withholding the names. Both refused to provide the unredacted records. This office is complying with the newly amended language in the privacy exemption that has not yet been interpreted by the courts in this regard, while at the same time protecting individual privacy rights, wrote Mary Lee, a Bristol County Assistant District Attorney. After the Dump said it planned to sue, the Bristol County office partially backed down and agreed to reveal most of the names. However, it still refused to supply the identities of officers who it said were exonerated from misconduct accusations. These records of exoneration are not records of a misconduct investigation, as the documents demonstrate no misconduct by those officers, Lee wrote. The records, therefore, are simply personnel records of those officers. The Dump's lawsuit alleges that this argument and others raised by the Bristol County District Attorney's Office to withhold additional records are erroneous. When it comes to police misconduct, the public has a right to know how internal investigations are conducted, said Mason Courts, the Dump's attorney. This is true, regardless of the outcome of the investigation. After all, the public has a strong interest in knowing who is not being held accountable for potential misconduct. He added, with the Public Records Law, while the Public Records Law recognizes an interest in individual privacy, it must be balanced with the public's interest in holding the government accountable. The legislature, courts, and supervisor of records have all addressed this balance. In this case, none of them support the district attorney's interpretation of the law. In a landmark 2003 decision, the State Appeals Court found that records from internal affairs investigations are not personnel records under the privacy exemption. That case concerned records related to a police officer who the Worcester Police Department exonerated from an excessive force allegation. A citizen raised full and fair assessment of a police department's internal investigation of its officers' actions promotes the core value of trust between citizens and police, essential to law enforcement and the protection of constitutional rights, the appeals court wrote. Disciplinary action is but one possible outcome. Exoneration and protection of the officer and the department from unwarranted criticism is another. In addition to the names, Bristol County office has withheld witness statements about alleged misconduct, records related to its decisions about whether to disclose alleged misconduct to defendants, and records related to prosecutions of police officers. Some of the withheld records concern Michael Pessoa, a former Fall River police officer who was convicted of assault and filing a false report in May and faces similar charges in 2 other cases he's implicated in. The DA's office cited a plethora of justifications to withhold this information, including the privacy exemption, the deliberative process exemption, the investigatory exemption, impoundment orders, and grand jury secrecy rules. The DA's office also cited a state law that allows people to sue for invasions of privacy, but stopped relying on this statute after the dump threatened to take them to court. In addition, the DA's office attempted to charge a $500 fee for copies of its communications with criminal defendants and their lawyers. These records would show how often the DA's office relies on police officers with problematic histories when building criminal cases. While the Public Records Law allows agencies to assess fees for records under some circumstances, fees must be reasonable and cannot be designated to limit, deter, or prevent access to requested public records, according to the text of the statute. Murray, the record supervisor, rejected the majority of the DA's arguments, although she declined to provide an opinion about the records related to pending prosecutions. The dumped suit against the Northwestern District Attorney's Office, which released Brady disclosures about more than 30 officers, but refused to provide any of their names, remains ongoing. The Northwestern's office response to the complaint is due by the end of July. Courts, who represents the dump in both lawsuits, is a clinical instructor at Harvard Law School's Cyber Law Clinic, which is part of the Berkman Klein Center for Internet and Society. The Cyber Law Clinic provides pro bono legal services regarding issues like technology, free speech, and intellectual property. In both lawsuits, Courts was assisted by Harvard Law students Vincent Roble and Carolina Rabinkowitz, the latter of whom has since graduated. In the Bristol County suit, Courts was also assisted by Sandra Asensio, a Columbia Law School student who is serving as a summer intern at the Cyber Law Clinic. The dump's lawsuits follow a March decision by a Suffolk County Superior Court judge that the Bristol County DA was wrong to withhold officers' names, reports, and other records related to the deadly shooting of Anthony Hardin by a Fall River police officer in November of 2021. The judge found that the privacy and investigatory exemptions did not protect records sought by Hardin's brother Eric Mack. The DA's office has since appealed the ruling, asking the Supreme Judicial Court to review it.